to ensure as the process moves forward, that council is kept apprised and gets to weigh in at all the various steps as all of this is moving. We thought it would be helpful to produce a written report to council offices every other week on status updates on all the different pieces so that everyone has the opportunity to weigh in throughout the process. We're open to doing it other ways. That seemed like the most streamlined way, making sure that everyone had the opportunity to be kept up to date and to weigh in. The other thing that we, my colleagues at the staff level and I will work out will be regular meetings of each of our offices together on all the various pieces so that at the staff level we're all coordinated and working with our bureaus.
And so thank you for that, but the clear intent is that if there are going to be applications of waivers of aspects of the building code, if there are going to be sightings that would normally not be allowed except for the emergency, that those would be discussed at those meetings and in the bi-weekly reports.
Correct.
Thank you.
Other questions, concerns about that proposed amendment? So let's take a vote to accept that amendment for purposes of testimony. If we're ready to do that, roll call, please.
Aye.
Thanks very much to the Mayor's Office for working through this. Aye.
Aye.
Aye. Aye. Thank you. Are there other amendments to either 1029 or 1030?
I have one to 1028.
Okay, so let's do the emergency declaration first. Okay, I don't think there are anymore. Okay, so do you have a proposed amendment for 1028?
I do. As we heard from Home Forward, 2 months, 3 months is really not enough time to be able to find a new place in the current housing market. So I would propose 30.01.085B and C that we change the notice to 120 days rather than 90 days.
Is there a second for that?
Second.
Okay. So, question to staff.
Well, I would like to have, I will oppose that amendment because I feel that what we're presenting to you today is something that is legally defensible, and I'd like to ask our city attorney to provide the city attorney's rationale in advising us that this is a 90-day notice is defensible and officially legal, whereas the 120-day,
Yes, the
Yours
memo
towards,
is the city attorney said that 100.
geared towards preemption. Lisa?
Sure.
Lisa Graham, Deputy City Attorney. So with regard to the first item that you were suggesting, 120 days for the notice itself, whatever the city does with regard to this code amendment needs to be able to exist alongside the Landlord-Tenant Act. And so it needs to be compatible with that. And so while that act sets the floor, so 90 days is sort of a reasonable amount of time that doesn't start to feel like it's foreclosing a right that the landlord otherwise has under the act, because the landlord does have the right under the act to terminate without cause. And so when we start to get into longer periods of times, it starts to just sort of edge towards the risk that we are foreclosing a right that's otherwise required allowed under the state statute, which we cannot run afoul of.
And why does 120 days seem so much worse, more likely to be allowed than 90 days?
It's just a question of reasonableness in terms of time.
I think because I also think we're going to be risking challenges who said that even 90 days is not legal.
Right.
So it's trying to strike, I guess.
It's a balance.
I use the threading the needle, I guess is how I like to refer to it.
So having read your excellent legal memo, which I thought was very well done, I would say that there's a lot of gray here and there's a lot of risk. So I appreciate your role of being cautious in this discussion. And the question is how much risk we're going to take at the risk of a court overturning this. Does it present less legal concern to you if instead of changing the 90-day framework, we drop the trigger on one of the notice provisions from 10% to 5% on rent increase?
In terms of you're just now talking about just the term, in terms of the percentage.
Yeah,
Percentage of the increase that triggers the 90-day notice.
Does it cause you the same heartburn if putting aside the question of whether we go from 90 to 120 days, I'm just asking, if we lowered the floor from 10% to 5% on the rate increase, which, or rent increase, which is subject to 90 days notice, does that present risk concerns to you legally?
I think that the 10% was a number that was struck upon as being sort of, trying to balance sort of the administrative burden on the landlord, or, in terms of, like as you mentioned, this is a very gray area, so trying to strike a balance in terms of what the administrative burden would be for issuing these notices. 10% was sort of a number that seemed a reasonable number.
We also heard from Mr. Stoll and some of the others that in fact, 5% increase is unlikely for him and his tenants. So there's two ways to get at this, it seems to me. One is extending the period of time, or two is changing the trigger. And I'm getting the sense that you have less concern about the trigger versus the time frame.
Yes, I think the time frame, to move on to that other amendment to C, 120 days. That's controlled, by a different part of the statute, which is the rent control statute. And having a period of time where, you cannot, where a landlord is not able to increase the rent extended to 120 days starts to feel more like we're running afoul of the prohibition on rent control. And again, 90 days seems like a more reasonable period of time where we're running less risk of running afoul of that.
Yeah, I would just, say that these risks are not, not imaginary. We have a legislative session going into session in a couple months. If we don't put something on the books that can withstand any amendments, then those amendments won't be proffered by Mr. Stoll in Salem, they'll be proffered by others. We just, we can fight a good battle, and we can fight a good battle for years, but I've been down there fighting for inclusionary zoning, and, I've seen the legislature give us goose eggs too many times to sort of blindly accept the fact that all we got to do is just, by golly, fight it hard enough and we will prevail. Maybe I've just been around too long, but I try to find the art of the possible, as I said, threading the needles of what I think is legally defensible, as opposed to maybe what is going to satisfy most people in this room today.
Well, the reason I applaud Dan for his approach is it's a Pyrrhic victory if we do something today that a court stays tomorrow, and then it doesn't benefit anybody. So let's find a balance that we can implement quickly, and then let's refine it as we learn more. But let's not put the whole package at risk. But Mayor, I do think the 5% floor presents less risk, and at least ought to be considered.
Then with that as a good discussion, I'd like to, my second approval, table the previous amendment and substitute that we change it from 10% to 5%.
I'll second that.
All right, further discussion about accepting that amendment before we take testimony? Okay, then roll call, please.
Aye.
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 No.
I'm going to support that. A very interesting discussion, because my assumption before this discussion we just held with our counsel was that our legal risk would perhaps be greater. But I'm pleased to hear that, and to me, now that I've heard that discussion, it makes sense why we're here. We're here because of a financial emergency, and therefore we ought to focus on the financial question. And we're trying to avoid harm to our citizens by extraordinary rent increases at a time where they have few other choices. So I'm pleased to hear that we think that's both a sound policy basis and focusing on the heart of the problem. Aye. Okay, so that amendment's approved. Are there other amendments before we take testimony? Other questions for our staff? Thank you very much. Please.
I'll just mention that I can't take credit for that excellent legal memo that was Tim Vanier in my office that wrote that. So.
Well done. Thank you very much. Okay, so let's turn to the sign-up sheet, please, and take testimony. And let's do this declaration of emergency first. So if you're signed up for that item, please, we'll take that testimony first, and then we'll move to the rent protection issues. So are we going to alternate? Okay, sorry. Somebody else figured this out before I did. Thank you. Let's alternate.
And we have a total of 48 aaaa39.
Okay, again, please try to limit yourself to 2 minutes, and if you've heard someone already articulate your points, don't feel like you have to repeat them. You can give them a thumbs up or stand up and say it's been said, but let's try to make sure we get to hear everyone. Please.
The first three, please come on up, are Marianne Drake, Dana Denny, and I believe it's Wahid Brown. And they'll be followed by Phil Owen, Jessica Blakely, and Melissa Mendez.
Welcome. Who'd like to be first? Go ahead.
All right, my name is Marion Drake. I'm a tenant, long-term member of Community Alliance of Tenants. First thing I'd like to point out is this conversation has been 99% male. You hardly hear any women's voices in this conversation that we just had. You folks just had. I want to point that out. Next, we do not need politically motivated shelters concerning the Sears building, which wouldn't happen anyway until after July 2016. The 10-year end homelessness plan that the city implemented 10 or 12 years ago didn't happen. And so this probably won't happen either. There's been a proposal, I think it was 4 years ago, there's an article in today's Tribune about this Sears building. There was a proposal, I believe it was 4 years ago, to turn the Sears building into housing, not shelters. And this has languished and nothing's been done. We need housing, we don't need shelter, we need shelters too, but what we really need is housing. Another thing is, Airbnb is flaunting the city regulations, avoiding lodging taxes, and has already effectively removed thousands of affordable and low-income potential, buildings, and potentially will do more. So we're talking about funding. We need to get Airbnb in on the act and enforce the requirements that they pay hotel lodging taxes, all the ones that are using B&B. I don't know how you're going to do it, but you got to do it. I'm also in favor of required mixed-use housing development with a 10% very low-income, non-subsidized housing included in any new developments. The City Council has been talking about extending one floor up for new buildings in exchange for what I understand is called some low-income housing. However, it doesn't give a percentage, and there needs to be a percentage, and I'm proposing 10%. Also, what is so-called affordable housing? I forget who it was saying that so much affordable housing has been created in the last few years. We need to be talking about, quote, this is my term, that I developed with several other people that are in low-cost housing now. We need very low-cost, non-subsidized housing. Because at a meeting I went to, was sponsored by KBRU about a month ago,